Donald Trump is confronting a moment that cuts deeper than any headline scandal or campaign controversy he has faced before. This is not about rhetoric, polls, or partisan outrage. This is about the law finally colliding with the financial mythology that has sustained his public persona for more than half a century. Courts are no longer debating whether Trump crossed legal lines. They have already answered that question. What is unfolding now is the consequence phase, where judgments are enforced, excuses run out, and accountability becomes tangible. At the center of this crisis is a sweeping civil fraud judgment arising from years of investigation by the New York Attorney General's office. The ruling did not merely reject Trump's defenses, it dismantled them. The judge overseeing the matter did not hedge or soften her conclusions. She described Trump's arguments as frivolous, legally baseless, and corrosive to the integrity of the judicial system. Legal analysts across the ideological spectrum noted that the tone of the ruling was unusually direct, reflecting a court that believed it was being asked not for justice, but for special treatment. Trump's legal team responded as they always have when faced with adverse rulings, by escalating. They filed emergency motions arguing that enforcement of the judgment was unconstitutional, that the case itself was politically motivated, and that compelling Trump to satisfy the judgment would cause irreparable harm to his business empire. These arguments were not new. They were extensions of a narrative Trump has relied on for years, that any legal setback must be the product of bias, persecution, or conspiracy, rather than the result of evidence and law. The court rejected every one of these claims, not politely, not ambiguously. The judge addressed them point by point and rejected them in language that left little room for reinterpretation. She emphasized that Trump had received full due process, had been represented by counsel, had cross-examined witnesses, and had been judged based on an extensive evidentiary record. The ruling made clear that what Trump was experiencing was not political retaliation, but the predictable outcome of conduct the court had already found to be persistent, deliberate, and fraudulent. This case is not about a single disputed appraisal or an isolated bookkeeping error. It is about a long, running scheme in which Trump and the Trump Organization repeatedly inflated property values when seeking loans and insurance while minimizing those same values for tax purposes. According to the court's findings, this was not accidental. It was systematic. Properties were overstated by hundreds of millions of dollars. Square footage was exaggerated. Restrictions on land use were ignored. Assumptions were presented as facts. And these misrepresentations were used to secure favorable financial terms that would not have been available had truthful valuations been disclosed. Among the most striking examples cited during the trial was Trump's Manhattan penthouse, which he claimed was nearly 3 times its actual size. Another was Mar-a-Lago, which Trump valued at over $500 million despite legal restrictions that significantly limited its market value. These were not borderline calls. They were dramatic departures from reality, repeated across multiple years and financial statements. When the case went to trial in late 2023, the court concluded that Trump had engaged in repeated fraud over a period spanning decades. In early 2024, the judge issued a judgment exceeding $450 million, including interest, and ordered the disgorgement of profits obtained through fraudulent conduct. Trump immediately appealed, as was his right, but appeals do not automatically pause enforcement of judgments. Under New York law, a defendant seeking to stay enforcement must post a bond covering the full amount of the judgment plus interest. This requirement is not punitive, it is protective. It ensures that judgment creditors are not left empty-handed while appeals drag on for years. It is a standard procedure applied to defendants across the financial spectrum. To pause enforcement, Trump needed to secure a bond approaching $500 million, either in cash or through collateral acceptable to a bonding company. This is where Trump's financial narrative began to unravel in public. His lawyers claimed they contacted dozens of bonding companies and were unable to find a single institution willing to underwrite a bond of that size using Trump's real estate as collateral. The explanation was straightforward and devastating. The very fraud findings Trump was appealing had destroyed confidence in his asset valuations. Financial institutions that evaluate risk for a living were unwilling to accept properties whose stated values had been judicially determined to be unreliable. The court was unmoved by Trump's protests. In her ruling, the judge pointed out the profound irony at the heart of Trump's position. He had been found liable for inflating asset values to deceive banks and insurers. Now he was insisting those same assets were so valuable that forcing him to leverage or liquidate them would cause irreparable harm. Yet when he attempted to use those assets in the real financial marketplace, no one accepted them at his claimed valuations. The judge effectively concluded that Trump's inability to secure a bond was not evidence of injustice, but evidence that the market agreed with the court. Trump's legal team attempted to argue that enforcing the judgment before the appeal concluded violated due process. The court rejected this argument as well, noting that the bond requirement exists precisely to preserve due process by ensuring that judgments remain meaningful. Without such safeguards, defendants could transfer or encumber assets during the appellate process, rendering judgments unenforceable. The judge emphasized that Trump was receiving exactly the process the law provides, no more and no less. Perhaps the most striking portion of the ruling addressed Trump's claims of political motivation. The judge did not merely dismiss them. She described them as insulting to the integrity of the court and unsupported by evidence. She noted that alleging a coordinated conspiracy involving prosecutors, judges, and the judicial system itself was a tactic Trump had repeatedly employed whenever he faced adverse rulings. The court made clear that such arguments were not a substitute for legal merit and would not be indulged. Legal commentators were quick to note the significance of this tone. Judges typically exercise restraint, especially when addressing politically prominent defendants. For a court to explicitly characterize arguments as bad faith and corrosive signals a belief that the litigation process itself is being abused. Several analysts observed that the ruling reflected a judiciary increasingly unwilling to tolerate procedural gamesmanship designed solely to delay accountability. This moment did not arise in isolation. It fits a pattern that has defined Trump's response to legal scrutiny for decades. Whether dealing with contractors, business partners, journalists, or government agencies, Trump's approach has been consistent: deny wrongdoing, attack accusers, flood the courts with motions, and delay resolution for as long as possible. In private business disputes, this strategy often succeeded because smaller adversaries could not afford prolonged litigation. Against state authorities with substantial resources, it has failed. The same pattern appeared in Trump's handling of classified documents. He denied possession, claimed unilateral declassification authority, resisted subpoenas, and framed enforcement actions as political persecution. When criminal charges followed, the arguments shifted, but the strategy remained the same. Delay, delegitimize, and hope external events intervene before consequences materialize. A similar approach defined Trump's response to investigations related to January 6. He asserted sweeping claims of executive privilege long after leaving office, encouraged noncompliance with subpoenas, and argued for absolute immunity. Each claim was tested in court. Each was narrowed or rejected. The legal system moved slowly, but it moved. The defamation cases involving Jean Carroll followed the same trajectory. After being found liable, Trump continued the conduct that led to the judgment, triggering additional liability. Even then, he resisted posting bond and framed enforcement as persecution. The pattern was unmistakable: behavior, denial, loss in court, escalation, delay. What makes the current situation different is that it strikes at the core of Trump's identity. His political brand is built on the image of wealth, deal-making, and business acumen. The fraud judgment directly contradicts that image. The inability to secure a bond compounds the damage. It suggests not merely legal defeat, but financial vulnerability. It implies that Trump's long-claimed billions exist more on paper than in liquid or reliable form. Legal experts have described this phase as a watershed moment. Andrew Weissman characterized it as the point where Trump's constructed persona collides with legal and economic reality. Eli Honig noted that the ruling's bluntness reflects judicial frustration with what appears to be serial bad faith litigation. Even commentators who have previously defended Trump acknowledge that the bond and enforcement procedures being applied are routine and legally sound. The implications extend beyond Trump personally. From a business perspective, enforcement actions against marquee properties can trigger cascading consequences. Many large real estate holdings are heavily leveraged. If lenders perceive increased risk, they may accelerate repayment schedules, tighten credit, or invoke default provisions. What begins as enforcement of a single judgment can ripple outward, destabilizing an entire portfolio. Politically, the optics are equally significant. Trump's appeal to voters has long rested on the claim that he succeeded where others failed, seeing that success questioned not by rivals but by courts and markets undermines that appeal. While his most loyal supporters may interpret enforcement as persecution, undecided and swing voters may see it as confirmation that Trump's business narrative was overstated. There are also broader institutional stakes. This case tests whether the legal system can enforce judgments against individuals with immense political power and devoted followings. If judgments can be delayed indefinitely through procedural maneuvering and public pressure, the rule of law erodes. If they are enforced consistently, it reaffirms the principle that legal accountability does not stop at wealth or office. Reactions within Trump's political coalition reflect this tension. Some voices advocate open defiance, framing enforcement as an existential battle. Others express private concern that the situation reveals vulnerabilities long denied. Still, others attempt to straddle the line, criticizing the process while distancing themselves from Trump's decisions. As enforcement proceeds, those positions may become harder to sustain. Trump himself has responded in familiar fashion, denouncing judges and prosecutors, portraying himself as a victim, and casting the case as a warning to others. But rhetoric cannot substitute for a bond, it cannot halt enforcement, and it cannot reverse findings already entered into the record. What makes this moment resonate is its simplicity. A court found fraud. A judgment was entered. The defendant appealed but failed to meet the legal requirements to pause enforcement. The law is proceeding as it does for others. No spectacle can change that. This is not about vengeance. It is about whether judgments mean what they say. It is about whether financial fraud has consequences when committed by powerful individuals. It is about whether courts can function when defendants attempt to turn legal proceedings into political theater. As enforcement continues and appeals move forward without a stay, the reality becomes increasingly difficult to obscure. Properties can be appraised, liens can be filed, receivers can be appointed. None of this requires a conspiracy. It requires only a judgment and a failure to satisfy it. In the end, this episode forces a reckoning. If Trump succeeds in delaying consequences indefinitely, it sends a message that wealth and power confer immunity. If enforcement proceeds, it reinforces the principle that no one stands above the law. That is why this moment matters far beyond a single defendant or a single case. What we are witnessing is not merely a legal dispute. It is a test of credibility, accountability, and institutional resilience. The outcome will shape not only Trump's future, but the expectations placed on those who claim power, wealth, and influence in American life.